Good afternoon, everyone, and welcome to this year's Tenants Introduction to Rent Control. This is one of several seminars that we put on during the year, some directed more to tenants, some directed to property owners. We have a maintenance seminar that we do with the Code Enforcement Division of the city, and we do a landlord-tenant forum with the city attorney's office every year. And this event is going to be recorded, and it will be available on our website, on our seminars page. So if you need to go back and reference anything you've heard today, you can do that there. It may take a week or so before we can upload the actual video, but this seminar and others are available there. Depending on your internet connection, you may experience some delays in the video, but hopefully you'll catch up soon. Sometimes the slides will change prior to the conversation that people are having. So it may be off a little bit, but hopefully you won't encounter too many problems. So with that, let me just introduce myself. So my name is Dan Costello. I am the Public Information Manager for Rent Control. And today I'm joined by two of our information coordinators, first Jenny Min and Micah Mitalski. They are two of the people who typically answer your phones if you were answer the phone if you were to call here with a question, and they are the ones who would meet you at the public counter. So they're people who are very familiar with answering the kind of questions that tenants have, and have helped prepare this presentation today. So we're going to cover several topics, just to be clear, this is really a seminar about rent control. There are a lot of issues that have to do with the landlord-tenant relationship that we're not going to cover today, and I'll talk about those in a minute. But I really want everybody to get a core understanding of what rent control is all about. Just as the name says, we control the rents. So that's essentially the power of the rent control agency and the board. It is to govern the rent that tenants can be charged. So we're going to talk about what the rent actually can be. We have something called a maximum allowable rent and something called a maximum lawful rent. And Jenny's going to go into that and explain all of the details about what is a lawful rent. We're also going to talk about what's unlawful. So, you as a tenant can look at the rent that you're paying, and if the property owner asks you to pay some additional amounts or something like that, you'll be able to know whether or not those are okay or if they might be problematic. And we would always want you to call us when you have some questions about the rent that you're paying. We'll have contact information at the end of the video, and you can always use our website to get information on how to contact us. You can also send emails to us at rentcontrol@santamonica.gov. After we talk about the rents and what's okay and what's not okay, we'll talk about the amenities and the maintenance that's required for rent-controlled units, and something called rent decreases, or really an administrative remedy that you as a tenant can avail yourself of if the property owner takes away an amenity that belongs to your unit or doesn't do the maintenance that's required. So we have a process, and we can help you with any kind of a situation like that. We'll also talk about some of the other remedies we have, including construction-related decreases and excess rent complaints. Finally, we'll go into the eviction protections that are under the law, and they're an important part of what rent control is all about. So before I go any further, I do want to show, we're going to stop during the presentation at various times to answer your questions. And if you keep in mind the topics that we're going to be covering, you may have a question that you might want to save for a little bit later to see if we actually cover the material you're looking for. But really, you can type in your question at any time. So you'll see that there is on the right-hand side of your screen a little icon with the person, and you can click on that and then type your question into the answer box there. Because this is a general rent control presentation, we would hope that you will have questions that are of general interest. If you do have questions that are very specific to your rental situation or some unique circumstance, it probably would be better for you to call us directly and speak with one of the information coordinators like Jenny or Micah, and they can help you with the specifics of whatever issue you're facing. So remember, we'll come back and we'll do questions as we go through the presentation. So we're going to begin with a little overview of what rent control is. So rent control became a law on April 10th of 1979. So we are about to celebrate 44 years in the community. And by now, we would hope that most landlords will understand the basic processes around rent control. And we hope that tenants will keep up with that as well. Of course, tenants and landlords are turning over from time to time, and so having a refresher is really useful, we think. So the way that rent control is structured is there is an elected rent control board, and you see the pictures there of the current board members. So they are elected members or appointed members if there's a vacancy. And they each serve a 4-year term, and they can serve 2 terms under our law. And they oversee the work of the agency. So they work very directly with the administrator, who is the person here at City Hall who really runs the operations, the day-to-day operations of rent control. And our agency is divided into 4 different divisions. So we have an administration division, which largely handles internal tasks. We have the public information division, which is the one that I'm a part of and Micah and Jenny are part of. And then we have a legal department. The legal department really services the rent control board itself. And so they will advise the board on legal matters, and they will pursue litigation if necessary or defend the board in litigation, but they don't provide any services directly to tenants. So sometimes we're called and asked if we can provide legal help, but you really would need to go to a private legal agency such as Legal Aid if you need assistance. We can't provide those services internally. We do have our hearings department also, and that is the section of the agency that handles all of the administrative remedies, like those decrease petitions that I was talking about, or excess rent complaints. But your first point of contact is always going to be the public information department, and then we can help you file petitions or seek any other remedies that you might need. So rent control applies not to all of the buildings in Santa Monica. That's a misconception by some people. Our law applies to most residential rental units that were in existence prior to April 10th of 1979 when rent control started. And as you can see on the map there, they're really all over the city. There are some neighborhoods that are mostly single-family dwellings, and those are one of the category of units that are often exempt from rent control. Some condominiums are also exempt from rent control, or they may just have decontrolled rents, but some of the eviction protections under the rent control law still apply. Then we have another category of units that are on smaller properties, typically 2 or 3 unit properties that are owner occupied. And while the owner lives on that property, it's not subject to rent control. So, you can, and Jenny's going to explain how to do this in a minute, but one of the ways you can check to see if your unit is subject to rent control is to go on our website and enter the address. If a rent is returned by the system, then that's a good indication that you're under rent control. If you have any questions, again, you can always call us. So I like to think of the rent control law as having as being a chair with 4 legs, and it needs all 4 of those legs to function properly. So those 4 legs are, one, like I mentioned, rent control. So we control the amount of any rent increase that tenants can get. We'll get into how the rents are set in the beginning later, but every increase to the rent is governed by rent control. So that's one of the legs. The second is providing those administrative remedies when there is excess rent charged, or if there's a maintenance issue or something like that. And the idea is that if you're not getting all of the services and amenities that should come with your unit, then the rent dollar is not fair, and some adjustment should be made. Rent control doesn't have the authority to compel an owner to make certain repairs or provide certain amenities, but we can officially reduce the rent as a way of incentivizing the owner to restore those amenities or do the required maintenance. The third important leg are the eviction protections. Some jurisdictions that have rent control don't have eviction protections, so owners could terminate tenancies and be able to reset the rents at higher rents. So it's an important part that tenants in Santa Monica have eviction protections, and they are very extensive. So we'll get into those later in the presentation, as I mentioned. And then the fourth leg is limiting the removal or conversion of controlled units. So if owners were able to just, take a unit out of rent control just because they wanted to, then we'd probably see more owners doing that and avoiding the other protections that are provided in the law. So all of these things are important for keeping our law effective. Now, going back a little bit to those things that won't be our focus today, there are state law issues and there are other issues that are covered by the municipal code. And because we are really rent control and we, our duty is really to explain the rent control law and the amenities that, or the services that we provide, we are not the best agency to talk about the state law or other things in the municipal code that are very integral to the tenant-landlord relationship. Some of those state laws are like the return of the security deposit. The rent control law does limit the amount of the security deposit that can be collected at the beginning of the tenancy, but the return is entirely state law. Another thing is the entry of the landlord to do repairs or other agreed upon maintenance or necessary things. Those are also state law issues. There are eviction procedures that are different from just the protections that we have under rent control. Those are how are you noticed, some things like that. Noticing, and that's the number of days before the owner has to give you a written notice to increase your rent or to change the terms of your tenancy. Those things are all specified in state law. We can give you general information, but anything that's very specific, we really would like to refer you to a state agency. There is a great publication called California Tenants, A Guide to Residential Tenants and Landlords' Rights and Responsibilities that is on our website. I put up a QR code here. You can actually scan it on your screen and open up that publication. But it's very detailed and it's written in language for anyone to understand, and it's a very great resource, and I encourage you to take a look at that. There are other things in the municipal code like tenant harassment. We often get complaints about how the landlord is treating the tenant. We only have the remedies that we have under the rent control law. We can't, compel an owner to be nice. But the city attorney's office will look at tenant harassment complaints, and they're really looking for instances where the owner is doing something in an attempt to get the tenant to leave. So the bar is kind of high, but you can approach the city attorney's office with tenant harassment complaints. When there are serious maintenance issues with a property or habitability issues, it could be that the city's code enforcement division requires permanent or temporary relocation. And we can guide you to resources regarding that, but we're not really the agency to help you with the specifics of, say, a temporary relocation order. Building code violations, similarly, there are some things that are, really can affect the habitability of a unit, and there may be some remedies available to you that are better than the rent control remedies, because ours take some time. Short-term rentals, we get complaints about those. Neighbors are, renting out their units, or owners are renting out units on a short-term basis. These are not allowed in Santa Monica. Each tenancy has to be for a minimum of 1 year. And it should be to a natural person, not to some, short-term rental company. And then finally, there are smoke-free residential laws limiting where people can smoke, typically not at all in the common areas of properties or within, I believe it's 30 feet of a door or window. So if you have questions about these things, you probably want to ask us those outside of this seminar because we won't really be able to address them here. So with that, let me turn it over to Jenny, and she will begin explaining to you what is a lawful rent.
Hi, my name is Jenny, and I'll be going over what the lawful rent is. Next slide, please. So we'll be going over two terminology that will be very useful for you to understand, be able to understand what your lawful rent is. So we have to understand what the maximum lawful rent and the difference between the maximum allowable rent and the maximum lawful rent. The maximum allowable rent, MAR, is the basic rent charge. It is the initial base rent plus the allowable yearly increase. It is not always the actual rent that one may pay every month. There are certain additional charges that may be added to the MAR as well. The maximum lawful rent, which is the maximum amount that can legally be charged for a rent-controlled unit, is composed of three things, which are the maximum allowable rent, registration pass-through, and allowable property tax surcharges. In order to be able to take the annual increase, tenancies need to be properly registered with us. If a tenancy is properly registered, the MAR we have on record would be accurate, and tenants and property owners may call us and request that information. Next slide. So how we determine the MAR is based on when the tenancy started. So up until 1999, all rents were based on the rent in effect on April 10th, 1978, and permitting market rate increase upon voluntary vacancy. So depending on when you moved into your unit, the MAR will either be based on the rent charged at the start of your tenancy or the rent in effect in 1978, plus all the substantial increase approved by the Rent Control Board. So for market rate tenancy, the new MAR is the rent collected over the initial lease term. To account for any periods or free or reduced rent, we would divide the total rent collected during the initial term by the number of months on the lease term. And next slide. So as Dan mentioned earlier, we do keep track of all the different MARs for all the rent-controlled units, and there are multiple ways you could find out. The first would be either calling, emailing, or coming into our agency during business hours, or you could go into our website and click on Look Up a Rent, and then typing in your address and the rent at that moment will come up. We also send newsletters, and as you can see on the top right corner, they would. This is something that you guys would have seen in the newsletter that you received a couple weeks ago. This year, we do have two different numbers, and I will explain that in the later slides, and that's because there was an adjustment to the MAR due to Measure RC. So the newsletter will reflect what is currently in our database. If a tenancy is not properly registered, our database will not have the accurate information. Next slide. So as I mentioned, there are three things that the maximum lawful rent includes. So the additional thing that can be added to the MAR is the registration fee. An annual registration fee for controlled units is charged to property owners by the Rent Control Board. Currently, the fee is $258 per unit per year. As long as the owner pays the annual fee on time, usually by August 1st, 50% of the registration fee may be passed through to each tenant by including an additional $9.50 per month to the tenant's rent. If the landlord does not pay on time, then the pass-through cannot be added to the tenant's rent. Next slide. Next slide, Dan. Okay, so the third thing that can be added is the allowable surcharge. And this would only apply to tenants that started their tenancy before March 1st, 2018. The allowable charges are based on the owner's property tax bill, and these costs can be divided among the units on the property and passed through to the tenants. The surcharges for existing tenants can be capped off at 4% of the MAR or $35, whichever is less. Surcharges cannot be passed through for new tenancy that began on March 1st, 2018, or if the building was sold and had its value reassessed. Next slide. So this is a sample of the property tax that lists the terms used for the specific costs as they appear. So if you could, I don't know if you guys will be able to read, but there's 5 taxes that can be passed to the tenants. And the 5 are the community college bond, the unified school bond, the school district parcel tax. It's also labeled as SMMUSD-MEAS-R. The fourth would be Santa Monica Stormwater Management Use Fee. The fifth would be the Clean Beaches and Ocean Parcel Tax. So again, this surcharge of the property tax can only be charged for tenants that moved in before March 1st, 2018. And another thing I want to mention is when you receive the notice, which I will show you an example of later on, owners must provide a copy of the tax bill when they are adding these surcharges to the rent. Next slide. So the general adjustment to the MAR, the purpose of the general adjustment to the MAR is to provide the property owners a fair return. The general adjustment, also called GA, is based on 75% of the percent change in the consumer price index for the Los Angeles area for the 12 months ending in March. The general adjustment for this year has not been determined yet. However, the general adjustment will be capped at 3%, and this is due to the Measure RC that passed this past November. If the unit qualifies and with proper written notice, the general adjustment can be implemented as early as September 1st of each year. If owners did not implement a previous year, it does not expire and can be prospectively implemented with proper notice. Next slide. So rent control provides a blank form to the landlords, and this would be something that would suffice as the written notice. And this breaks down all the different things, all the different components that we just talked about. So you could expect a written notice of either this form or a different version of this form before August 1st for the September 1st increase, unless your tenancy began on or after September 1st of last year. So we'll briefly go over how to read this notice. So as you can see, there are section A, B, C, and D. So section A, line 1 will have the old MAR. Line 2 would be the general adjustment, that percentage, or in dollar value. And when you add lines 1 and 2, then we get line 3, which will be the new MAR. Section B is the rent control fee pass-through. And again, if the landlord paid, this will only be passed through if the landlord paid on time. Section C is a surcharge from the property tax bill. And as I mentioned earlier, surcharges cannot be passed to tenants that moved on or after March 1st, 2018, or if the property was reassessed on or after March 1st, 2018. And the owners must provide a copy of the tax bill to the tenants with their rent increase notice to pass these past most surcharges. And when we add up all the lines, then we would get section D, which is the new maximum lawful rent. Okay, so this form specifically is for the adjusted GA for 2022, and so there will be an updated version of this for the increase in September. Next slide. So there are certain waivers for the surcharges and the registration fee. Waivers are available for rent control low-income tenants who are disabled, seniors, or on government-subsidized programs such as Section 8. If the waiver is granted, no registration fee will be charged to the unit in question, so no pass-throughs. When low-income tenants receive a clean beach and ocean parcel tax, a portion of the tax is reduced on the owner's property tax bill. So they would not be also be paying that portion of the clean beach and ocean parcel tax. Next slide. So in November of 2022, Measure RC passed, and this made the there was an adjustment or adjustment to the general adjustment, and this reduced the maximum general adjustment from 6% to 3%. The adjusted MAR for units increased 6% per the September GA to a 0.8% increase effective February 2023. Adjusted MAR for the units increased the $140 maximum per September GA to a $19 increase effective February 2023. So essentially, because the increase went from 6% down to 0.8 so that it could average out to a 3% in the course of the year. And the year in rent control starts in September and ends in the following month in August. So 2023 general adjustment will be based on qualified MARs in effect in August 31st, 2022 plus 3% or $70 maximum. And something to note is this is the first time that this has happened where there was two different adjustments in 1 year. In the next slides, I will be going over some examples of how the math works out with Measure RC. Next slide. So in this chart, you could see that from September to January, they got the 6%, and come February, it went down to 0.8% increase so that it averages out to a 3%. So in this example, if your MAR was $2,000 in August of 2022, a 6% increase would have been $120. Starting February, it would go down to 0.8, making the increase $16. When we average out the rent, what the rent was increased by in the course of the year, it will come out to $2,060, which is a 3% increase. Next slide. In this one, we're looking at if they receive the maximum dollar value. So if the rent was equal or greater than $2,313 and there was a dollar cap of $140 for the 6% and a dollar cap of $19 for the 0.8% increase in February. So if the MAR in August 2022 was $3,000, then starting September, the new MAR would be $3,000 plus $140, which would equal $3,140. Come February, the adjusted general adjustment would be 0.8% or a cap of $19. This will make the new MAR starting February $3,019. When we average out the rent in the course of the year, it comes out to $3,069, which averages out to 3% or $70 average. Next slide. So if the increase from September 2022 to January 2023 was less than 6%, the adjusted increase may be above 0.8%, but not more than 6%. The average rent for the period from September 2022 through August 31st, 2023 is 3% or $70 per month, whichever is less. In the next slides, I will continue on with more examples. Next slide. So in this example, starting September, this person received a 3% increase. So that means they could continue on receiving the 3% and there was no adjustment needed or no additional notice. So their old MAR was $1,000. In September 2022, they got an increase, a 3% increase, which was $30, which would make their new MAR $1,300, and it averages out to 3% as well. Okay, next slide. In this example, from September to February of 2023, which is 6 months, they did not receive any increase. In March, they did receive an increase of 6%. But when we do the math and average out everything, if you do the math of averaging, then it comes out to an average of 3% in the course of the year. So this is another way that Measure RC allows it. Let's look at example 3. So in this case, when we do the math from September to March of 2023, they received for 7 months, they received a $100 increase. And then from April to August, they received a $28 increase. So when we do the math again for the averaging, it averages out to $70. But when we multiply 7 times 100, we get 700. And when we multiply 5 times 28, we get 140. When we add up the two subtotals, then we get $840. And when we divide that by 12 months that you paid for, then we get the average or the dollar value of $70. So this also fulfills the regulation for Measure RC. Next slide. So all tenants and property owners of a rent-controlled unit received the mailing back in December 2022, and also a newsletter a couple weeks ago. Owner mailing included a MAR report and a notice of change in terms of tenancy template that you saw in the previous slide. And owners had to give tenants a notice of change effective February 1st, 2023. MARs for eligible units has been updated in our database on February 1st. Do you guys have any additional questions?
Thanks, Jenny. Yeah, we did have a few questions come in that are relevant to this section. So first, one person asked about the fee waivers that are available and wondered what the income limits were. So those depend on how many people there are in the household, and it's the same for the senior tenant and the tenant with a disability. So for a one-person household, it's $33,600. For a two-person household, it's $38,400. For a three-person household, it's $43,200. And for a four-person household, it's $48,000. So you'd have to have a household income lower than that for all of the members of the household to qualify for the fee waiver. The fee waiver application is available on our website if you look under registration fees and waivers, and you can get the form there to apply. Or you can contact our office and we'll send you one of those forms. Another question was, if your rent was not increased in September, what is considered proper notice for the landlord to increase rent at any time after that? Is it legal for it to be retroactive to September? Jenny, you want to handle this one?
Yeah, so based on example, I believe,
and go back.
Example 2, it is allowed that there could be a 0% increase, and starting March, they could give you that 6% increase as long as that the increase that you received would average out to a 3% in the course of the year. And the year doesn't start in January, it starts in September of one year, and it goes to August of the following year.
Right. So another part of this was to say that any increase in 1 month could not be more than 6%. So if the owner still hasn't given rent increase notice, then and we're already into April, it may be that there are only 4 more months left. And because they cannot charge more than 6%, they're not going to be able to reach the average 3% for the year. You would have had to have 6 months at 0 and 6 months at 6% to average 3%. But now the opportunities for the landlord are kind of dwindling to fully capture this year's general adjustment. As Jenny said, though, next September's increase is going to be based on the MAR in effect on August 31st, 2022. So your old MAR plus 3%, whether or not the owner actually gave notice of that 3%. And that's the way rent control works in Santa Monica. As Jenny mentioned, owners can defer taking general adjustments from year to year, and then they can give a notice that would catch them up to the current MAR. They can't go back in time and try to collect it retroactively as if they had noticed you, because state law requires that you get a notice and then any increase is prospective, but it would be limited by what's allowed in the rent control law. We have a couple of other questions, Maria and Veronica, we will get to because they are included in the upcoming sections. So if you can just hang on. Right now, let's see. So somebody also asked, how is the city policing Measure RC? Well, that's what rent control is for. You can, if you get a notice of increase and you're not certain whether it's lawful, you should contact our office and talk with somebody like Jenny or Micah, and we can look at it and see if what the owner is doing is lawful. If it's not lawful, you would be able to avail yourself of the excess rent remedy. And Micah will be talking about that shortly. I think it's Micah. Oh, yeah, it is Micah. Someone asks, what can I do if I am paying $3,100 for a unit with a MAR of 913? I have been paying this amount for a year and a half without knowing. Jenny, do you want to answer that?
So most likely the landlord hasn't registered your tenancy, which is required. So once the old tenant vacates, voluntarily vacates, the MAR or the rent, the initial rent would be considered, your initial rent would be the new based MAR. And from there, that would be the MAR, and then the general adjustment will be added on in the years to follow. So it's not going to be always the same from a previous tenant.
Right. So that happened. So that MAR of 913 sounds like it was probably a longer term tenant, maybe who moved in before 1999, and this is the first time that the unit has been rented since 99, and the owner is able to set a new base rent, which they did at $3,100. But they are required to register that with us. So I would encourage you to contact us, give us your address, and we will contact the owner and make sure that they know this registration requirement. We do also have some other remedies you could avail yourself of, a non-registration complaint. And we would, again, get in touch with the property owner and let him or her know that they need to register your tenancy. There's no way for us to know, to control the rents, if they don't keep up with the registration requirement. Someone asked, how was the month for the update of the MAR change in 2023 chosen? Rent update effective starting in February versus March or April. Well, that is a good question. It's a sort of complicated answer. The simplest solution would have probably been to use the example that's on the screen, or I'm sorry, the reverse of this. So 6 months at 6%, and then starting March have 6 months at 0, and we would have averaged to 3%. But the city was also offering the rent control adjusted relief program, and that assisted households that were rent burdened, meaning they were spending more than 50% of their income on rent, and were low income. And the city had funds available to pay the amount of their increase, just this up to 6% or $140 for this year. And it was hoped that if Measure RC, which was put on the ballot for November, passed, then by February, this program could be in place and starting, I'm sorry, through the end of January, this program would be in place. And then starting February, those rents that had gone up 6% would have gone down to a 0.8% increase that would have been more affordable. So it was because of I think it was influenced by the Rent Control Adjustment Relief Program that this was the implementation of Measure RC began in February. All right, so with that, I think we should probably move on to the next section. Don't see any other questions that are relevant to this section right now. So we'll go on to what are the unlawful increases, and Micah will take it from here.
Yeah, thank you, Dan. Go ahead and jump in. Next slide, please, whenever you're ready. So the base rent of the unit, as Jenny was talking about before, thank you, Dan, for turning on my camera. I was worried about bandwidth issues, but it'll work. The base rent and the amenities that come with the unit are established when either pre January 1st, 1999, they're based on, as Jenny said, what was in effect April 10th of 1978, or for post January 1st, 1999 tenants, they're what came with the unit when the tenancy began. So charging for additional amenities are not allowed within rent control, except under very specific circumstances that they need to be registered. So charging for additional amenities without a proper agreement may constitute the collection of excess rent. Slide, please. So for these pre-January 1st, 1999 tenancies, the owner and the tenant may negotiate a separate agreement for the monthly rental of amenities that are not base amenities that were not originally included. Separate agreement requirements must be negotiated separately from the rental agreement. They must contain terms comparable to those similar arrangements in an unregulated market. Continued existence of the agreement is not a condition of the tenancy. The breach or termination of that agreement is not grounds for eviction. So if for a certain amount of time you agreed to have a pet added or a parking or storage, something like that, and you no longer wanted to continue that, or the landlord was no longer able to provide that, that would not be grounds for terminating the tenancy. Next slide, please. So for folks that moved in after January 1st of 1999, these separate agreements, essentially they're not called separate agreements anymore, but they are limited to parking or a garage, storage, and the right to have a pet. Again, these must still be an arm's length negotiation with no pressure on the tenant to accept the amenity. It can't be forced upon the tenant to have something added. The amount paid for the amenity must be comparable to a lawful arrangement in an unregulated market. So it needs to be a fair market value. And the owner must register that initial amount charged for that new amenity with the board. And that amount is then rolled into the MAR. So it is then subject to the general adjustment each year. So that number all gets combined together, and that is what gets adjusted each year by the general adjustment. Slide, please. So one thing that's different in Santa Monica compared to some other local jurisdictions is there's nothing in the rent control law that allows owners to charge additional fees simply for adding an additional occupant. A tenant's right to sublet their unit or have guests is usually controlled by the terms of the rental agreement, and violations of the rental agreement could be grounds for eviction, something that could be covered under a just cause for eviction. The municipal code prohibits an eviction based on occupants being added if it's due to marriage, a domestic partnership if properly registered, birth, adoption, or change of legal custody of a child. The tenant sublets and no longer permanently resides in the unit. The owner may be entitled to raise the rent as long as once the last named occupant has vacated the premises and no longer lives there. That would trigger a vacancy-related rent increase. State law. Next slide, please. So with utility costs, this is something that's coming up a lot lately because utility costs have been going up. So it's important to know that where a unit is separately metered and the tenant pays the utility company directly, a tenant can be required to pay those utility costs. Not a direct payment to the landlord. This is being required by the terms of their lease to go and create an account with somebody like the gas company or SoCal Edison, because that unit is separately metered and the utility is just handled in that way. If a property is master metered and the lease requires a tenant to pay a share of the monthly utility bill, the owner is required to specify the exact dollar amount that contribution is going to be start of the tenancy, and that number cannot fluctuate up over the maximum allowable rent. It's part of that base rent. So it doesn't really take into account necessarily the months where the gas bill might be higher or lower. It just needs to be something that's included in the base rent, and that would be adjusted each year by the general adjustment as the total amount of the rent is adjusted. Next slide, please. There is something called tenants not in occupancy, and this kind of goes back to the slide a couple slides ago about tenants subletting. The rent-controlled unit is supposed to be used as that tenant's primary residence and usual place of return. So if an owner believes that a tenant, he or she may file a petition with the board to raise the rent to a comparable market rate rental. There are some formulas that need to be taken into account that either have to do with comparable units within the building that have been recently rented, or if there are no comparable units in the building, then the area median average for comparable units in terms of number of bedrooms for that neighborhood, and we have different zones that are designated in rent control. A decision in favor of the owner that says, yes, rent control agrees this tenant is not in occupancy, is not a just cause for eviction. It just allows the landlord to raise the rent to a more market rate rent. But it is not something that is covered under the just causes for eviction, so it does not allow the landlord to simply terminate the tenancy because rent control determined that their tenant is not in occupancy anymore. Next slide, please. All right, so complaints for excess rent, and this is one of those. There's a question in there about how do we police, Measure RC. Complaints for excess rent is the primary way that we're able to do that. So a complaint for excess rent may be filed by tenants or subtenants who believe they have been or are being charged amounts that exceed what is allowed by the rent control law. The rent control hearing examiner finds that excess rent has been collected. The tenant will be authorized to withhold rent until the amount of excess rent has been recovered. The rent control board can issue awards for excess rent collected in the previous 36 months. So we can only go back 3 years. So if you do think that you've been paying excess rent for an extended period of time, if you want to call our office, get started on that process soon, because every month that goes by, we're still limited by 36 months. So we can't, if you wait to file, you may be losing months that you've already paid that excess rent. Obviously with the adjusted general adjustment, that hasn't been going on that long. We're still in the first several months of that. But in some cases, some people may have been paying excess rent for longer, and they don't wait, is the advice there. It does need to be at least $100 extra rent that has been collected by the landlord before we can proceed with excess rent complaint. So if your adjusted general adjustment only has you a few dollars over, you may have to wait a little while before we can accept that complaint. But once it hits a $100 threshold or is getting close to it, the hearing officer may accept that excess rent complaint. So give us a call and we can talk through your specific situation if you feel like you may have been paying excess rent. Next slide, please.
All right, that brings us back to another one of our question slides. So if you have any questions regarding this particular section on what's an unlawful rent, okay, somebody's asking about the decreased petition process. We're going to talk a little bit more about that soon. Actually, a couple questions on that. I did want to clarify, when an owner decides to include some master metered utilities in the rent that's paid, as Micah said, they have to specify that up front. And that's just part of your base rent. It's not a separate charge, and it can't vary. As water rates go up, the owner has to tell you, I'm including, $100 in whatever I'm collecting to compensate me for your water usage. But that's locked in to the rent, and then it only goes up by the general adjustment. And same as those other added amenities like parking, storage, or the right to have a pet, those get combined with the rent. So they're added to the base rent after, so much time has passed perhaps. But then it's as if that is part of the regular rent and it only goes up by the general adjustment. So a common example is parking, and owners want to just claim that the garage they're renting is not part of the unit and that they control the rent for that garage. Well, that's not how it works in rent control. It would be that way if the tenant moved in before January 1st, 1999, and parking was not included in the rent on April 10th of 1978 when those rents were set. But for newer tenancies, the amount for parking is combined with the rent and can only go up by the general adjustment. Let's see if there are any other questions. So can a landlord increase rent for a new occupant, i.e. a boyfriend, girlfriend moves in or a family member moves in? Micah, you want to take that?
Sure, yeah, so we did talk about that earlier. The only, the landlord would not be allowed to raise the rent just for adding an additional occupant. They may, depending on terms and conditions of the lease, be able to deny adding that person. You're not, for example, replacing a roommate who left on a one-for-one basis. They may be able to say, no, your lease says one person, you can't move in a significant other. A spouse or newly born, newly adopted, or change of custody of a child would allow you to move those people in under city law, but the landlord does not have a mechanism to charge more rent because of those life-changing events. But the question here is specifically about boyfriend, girlfriend, family member. If that family member is not a spouse, not a child that you have custody of, the landlord could potentially just deny allowing you to add that person to the tenancy.
Yeah, in the next section, we're going to talk a little bit more about what are amenities to a unit, but having the right to a roommate is an amenity. So if your lease, says that the unit is being rented to, person A and person B, then two people are considered to be a base amenity for that unit. Now that is for tenancies started January 1st, 1999 and after. For those earlier tenancies, we have to go back to how many people were allowed in the unit. Well, actually, two different things. one, if there is a written rental agreement, we would look at the written rental agreement and see what the rental agreement provides. And a tenant could replace a roommate and collect rent from them, even though the lease might say there's no subletting, and yet the master tenant is collecting rent from their replacement tenant, person C. They cannot be evicted for that reason. Also, for pre-99 tenants, we could look back at April 10th of 1978, and if we knew how many people lived in the unit on that date, that's considered a base amenity or base housing service, and owners have to maintain that base housing service throughout the tenancy because the rent was based on that amenity and will always be based on that amenity. And our regulations even allow a hearing officer to reduce the rent in half if, for example, two people are the base housing service and the owner refuses the tenant to replace one of those people. So we have a petition process for that. But there isn't any just right to bring in a boyfriend or girlfriend different from a spouse or a domestic partner.
And then, Dan, I do see a question here about when the landlord can increase the rent to market if and when a tenant moves out. Yes, that's true. That is called a vacancy-related rent increase. So once the unit becomes vacant, once the last named tenant, got a lot of movement on my screen here with arrows and stuff. I'm sorry about that. Once the last named tenant on that lease moves out, then the landlord is free to set a new market rate, and whatever they can get an agreement for somebody else to move in, that's going to establish the new base rent for that new lease. And then the future increases on that new base rent are what is controlled.
Yep, and that is the effect of the state Costa-Hawkins law. So that's the vacancy decontrol, and we always have to allow the owner, if they have that qualifying vacancy, to reset the rent at whatever the market will bear, unless there's a rare circumstance in which the law does not allow that. Pretty rare situations, though. All right, I don't see any other questions that are right on this topic, so we'll move on to amenities, maintenance, and the rent decrease process, and Jenny will take it from here.
I believe Micah is covering this topic. I'll be covering evictions.
Yeah, I can keep going. Dan, you want to move past this title screen slide for me, please? All right, so, there we are. Owners are required to maintain the property, base amenities, and housing services. So amenities and housing services that were provided on the base rent date. So remember, that's either for those that moved in before January 1st of 1999. That's what came with the unit when it first came under rent control, what was being provided with the unit April 10th of 1978. That's what was registered. For tenants that moved in January 1st, 1999 and after, it's what came with the unit when the tenant first moved in. So what was typically included in the lease, or what you had when you moved in after that date. Examples of amenities include things like parking, appliances. So if your unit came with a stove or a refrigerator, or a microwave, those kind of appliances. And then the right to have roommates, like we were just talking about. So that was, if there were 3 people on the lease when you first moved in, that is the base housing service for that unit, is 3 people. But the base amenities also include things such as common areas, gardening, laundry, that on-site laundry room. It could be laundry in the unit. That would be a base amenity. If there's a recreation room when you moved in, if it had a nice gym or if it had a pool, things like that, Those are things that could be base amenities. Owners must also maintain the condition of the unit. Common examples of maintenance would be things like water leakage, worn paint, normal wear and tear on paint, flooring. So like if your carpet wears out over a certain amount of time, that is something that the landlord does need to maintain. Broken windows or doors, screens, if there's an insect or animal infestation, your heat, your plumbing, your smoke alarms, counters, grout, caulking, tile, anything like that. Those are all just the base amenities and housing services of the unit. Yes, these are things that may wear out over the years of somebody living there, but they're still part of your base rent at the condition that they were at when you agreed to move in. So those are things that the landlord does need to do maintenance on. If they don't, then you're not receiving the full value for your rent dollar. Next slide, please. So if you feel like you are not getting the full value for your rent dollar, you can file what we call a rent decrease petition. And it can petition for a rent decrease when an owner reduces or removes base amenities or housing services or fails to make necessary repairs. Decreases are calculated from the time the petition is filed. So this is a prospective decrease. It doesn't go back to when you first had an issue. It won't go all the way back to when a tile first broke. It would go back to the first time rent is due after you submitted the petition to our office, after it was accepted and it was considered filed. The rent decrease remains in effect until the repairs are made or the amenities or housing services are restored. Next slide, please. We also have another kind of a decrease called a construction-related rent decrease. This may be granted when a unit is uninhabitable due to construction, when construction substantially reduces a housing service, or when construction interferes with a tenant's ability to occupy the unit as a residence. Fortunately, no decrease is authorized or available for unavoidable construction impacts caused by necessary repairs, maintenance, or things that are mandated by a government agency, unless the construction is carried out in an unreasonable manner or the construction takes an unreasonably long time to complete. Regulation 4400 sets a decrease range for many possible issues. This is not meant to be a completely exhaustive list, but it is kind of the most common issues and the most common ranges. And then even within those ranges that exist in the code, the hearing officer does have the authority to go above or below that amount depending on the severity of the impacts. With both of these kinds of petitions, the first step is to try to mediate the situation. So we do have a trained mediator who will sit down with everybody. Usually it's on this same platform of BlueJeans. They have a different module on it that allows people to have a conversation, and they'll try to mediate a settlement agreement and try to get things done. Most of our petitions, I don't have the number with me. I know that we're checking what that number is for our next annual report, but most of our petitions are mostly resolved, if not completely resolved, through mediation. So it has been a very effective service. Next slide.
All right, that brings us back to questions on the decreased petition and amenities. So I'm going to go back to earlier. We had a question. So if a building has garages, are they considered an amenity? If so, should they be made available to tenants in the building, or can landlords rent them to non-tenants and tenants as well? Micah, you want to take it?
So, Dan, actually, I have a little bit of confusion about, because I've heard that code can say, no, you can't rent this to an off-site person, but I need some clarification on that. Actually, that would be helpful for me, and I'm sure some of the people that are listening. So do you want to?
Sure.
Mind?
Well, for, again, the city has rules within the municipal code that have to do with how buildings are used, what their licensed purpose is. And code enforcement may have some rules regarding garages. But from the rent control perspective, a garage is only a base amenity to a unit if it's a pre-99 tenancy that the garage came with that unit on April 10th of 1978. And you may have the question, how do we know? Well, owners did register their units with rent control back in 79 when it started, and they listed the amenities that came with each unit. That list may not be exhaustive, but it's a pretty good indication. It's considered to be correct what the amenities were for a unit. For tenants who moved in after 1999, a garage is a base amenity only if, one, it was rented with the unit, so it was an amenity on the base rent date, or when the amount of rent was set, the tenant had the idea that the unit came with the garage. Or two, remember we talked about those added amenities. So it's possible for post 1199 tenancy to have a garage added to it. And then once it's added and the owner and the tenant, negotiate arm's length transaction, how much they're going to, how much the garage is going to cost, that gets combined with the maximum allowable rent and then is controlled by general adjustments. So for us, it really depends on, is the garage a base amenity? And if there are other garages and they're not rented to a tenant, then they're not base amenities for an existing tenant. And we can only compel an owner to provide, we can only affect the rent level if an owner doesn't provide what's a base amenity. So that's the way that works. Let's see. So we have the question, this tenant has been in a 20-year renter in the same unit and needs a new oven and hood. The owner knows this. Do we have the right for a new appliance and hood? They, quote unquote, replaced it once with the used one they gave us. We did not want another used one. When we moved in 2002, it was a new oven. So is that something you could file a decrease petition for, Micah?
Yeah, absolutely. If you're not getting the full value for your rent dollar because you're not getting that, that appliance needs to be replaced, or it's not the condition that you agreed to when you moved in, that is something you absolutely could file, and we absolutely would hear that as part of the petition process. The ranges on decreases can be pretty broad. So if the oven is just one that you don't like the aesthetics of it, but it's functionally fine, your decrease may be significantly lower than if your oven didn't work at all. That would be something that would get a much higher award within the range of the possible decreases that could be awarded. So it is something that needs to be evaluated on a case-by-case basis. Hearings does have an investigator that goes out and takes pictures and evaluates the situation and the condition of the appliance or whatever else it is that you're petitioning about. That's all something that all things that get heard, both in the mediation. The investigation doesn't happen until after the mediation, but the investigation gets heard during the hearing. And your ability to bring up your concerns about the appliance happens in mediation. So those are definitely all pieces of the decrease process that can and will be affected.
Yeah, and again, get the answer here is that we can't make the owner replace the oven or the hood. All we can do is affect the rent level in such a way that the owner might be incentivized to make it whole for you. But we can look at qualitative things kind of as much as just kind of quantitative things. So, deteriorated cabinets or paint that's chipping, all of these things can be reasons to adjust the rent if the owner doesn't take care of the issues. And the question also says the owner knows. It's important for a tenant who wants to file a decrease petition with us to have a copy of a written request to the owner in writing. Well, in writing, of course, but it cannot be more than 180 days old, and it cannot be within the last 30 days. So you have to give the owner at least 30 days to address the problem, and then not more than 180, because then you would need to renotice. And if you want to file a petition with us, we do need to see a copy of the exact notice that you gave to the landlord regarding the condition. We have a tenant who has a petition for rent decrease and went to hearing, all done, but they never heard the outcome. And I've already waited 4 months at least with no word from RCB. When do I get an answer? Unfortunately, because of the volume of cases that we get, and sometimes due to the complexity of some of those cases, it's difficult for the hearing officers to render their decisions quickly. Initially, we do attempt mediation, and that takes some time to set up. Sometimes there will be delays, but we are working on adding efficiency to our hearings process and trying to get those decisions out sooner. The way that the petitions work, though, as Micah explained, is any decrease that would be awarded from the date that the petition was filed, not when the decision comes out. So even though there's this time during which you're waiting for your decision, we are going to compensate you, if there's a hearing decision in your favor, from the time that you filed. So that's what I can say about that. I have lived in my apartment for 13 years, and my landlord won't let me update anything, paint, carpet, etc. Are we entitled to updates after a certain amount of time, and how do we enforce this?
So there's no set amount of time that exists in the rent control regulations. It's really on an as-needed basis. So as paint deteriorates, as carpet deteriorates, once you feel like it needs to be placed, then you need to give your landlord the written notice requesting them to replace those amenities. And hopefully they do that within 30 days. If they don't, then you would file that rent decrease petition. Now, the landlord's not required to update or upgrade anything, because that goes above and beyond your base rent. This is about trying to find that level that is where your value for your rent dollar exists. That's that level that you agreed to when you moved into the unit. And the landlord does need to replace carpet after a certain amount of time, but it could vary depending on the quality or type of carpet that was installed. So there's no fixed amount of time attached to that. It's really just when the carpet needs it, you give that written notice to your landlord, and they should make those necessary repairs or replacements.
Yeah, there are some rent controlled jurisdictions or rent stabilization jurisdictions that do have specific time periods after which the owner has to repaint or recarpet, but ours is all based on the condition, which can in some circumstances be beneficial because things can happen, within the time period, that other jurisdictions have, and something, may need to be repaired or replaced, but we can deal with that through the decrease petition process. What about epoxy on sinks and tubs, also mold? Can you go over what the criteria is, how it should be determined, and what remedy the landlord is responsible for? I'll go ahead and take this. This is a challenging question. So, if there were a decision by rent control that the rent is going to be reduced until the owner took care of a problem, then the owner would 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 be able to go in and do the repairs that are necessary. If there are if a tenant has health concerns, for example, maybe sensitivity to chemicals, then we would expect some reasonable accommodation for that tenant. It may be possible to contact the city attorney's office and see what rights you may have to a relocation if certain toxic chemicals are going to be used. Among the resources you also have as tenants is the LA County Health Department. And you can contact the LA County Health Department because they can also advise on, what's allowed and what's not allowed. Mold is a very difficult item to deal with because, in fact, mold is everywhere. As I understand it, the state health and safety code says that it's a violation if mold is growing on surfaces that are not designed to get wet. But I'm getting a little outside of my territory because now we're talking about those state laws and things that also code enforcement might be able to look at. As far as rent control goes, if there is mold, visible mold, because we need to be able to see that, then it's a possibility that there could be a reduction in the rent until the owner takes care of that problem. Sometimes mold is not visible, and yet tenants can smell it or sense it. And it may be necessary in that case to hire a professional mold inspection company and get a professional assessment done of the results, because a hearing officer here, or even say a code enforcement officer, is not trained to be able to digest a mold report and know at what levels certain types of mold are dangerous. So it's a very difficult thing to deal with, especially now that we've had a lot of rain. It's a possibility that more tenants are going to complain about mold growth, but certainly mold growing on surfaces that are not designed to get wet are likely a problem. And also, code enforcement might want to look into the reasons that the mold is there. Is there a roof leak? Is the drywall saturated and moisture is accumulating and causing or allowing the mold to grow? But it is something that can be part of a decrease petition. Again, the landlord needs to be noticed about it and given the opportunity to remediate that situation. We have the question of, can you provide examples of unreasonable manner and unreasonably long time? And this is a reference to the construction-related decrease. Micah, can you handle that one?
I don't think I have a good answer for that. It's one of those things that I feel like you kind of know it when you see it, but I don't have it defined. I can't say that this permit should take 7 days to fix, and now they're taking 21 days, and now that is not reasonable. This
Right.
is something that I like to leave in the hands of the hearing officer to determine if they feel like this is reasonable.
That's right.
Or unreasonable.
Yeah, it's so many of these things are case by case, and that's one of the reasons why we have hearings, because a hearing officer needs to look at evidence. What did the owner do? Was it reasonable, not reasonable? But there's case law that does not allow us to reduce the rent unless it is being done on an unreasonable time frame or an unreasonable manner. Typically, on a big project, a property owner would be required to get a means and methods plan, especially if tenants are going to be affected. And they should be adhering to the terms of that means and methods plan. That's something you can talk with code enforcement about. If there's something going on and maybe there are access or egress issues that need to be addressed as construction is happening. So it's a little bit difficult, but I think the key thing is you can contact us and let us know what's going on, because that's really how these construction decreases begin. So the tenants contact us and tell us about the situation at their property. We may send out our inspector to look and gather evidence about what seems to be going on. And then we will send a letter to the property owner and to the tenants saying that it appears that we will accept, it appears that there is an issue here and we will be accepting construction-related decrease petitions. And then we'll see if we can get some movement on that, or the tenants will file the petitions, and the hearing officers will look at the actual circumstances and determine how much the rent should be reduced for those conditions. Okay, more questions about mold, as usual. Okay, somebody asked if there is a way to get a list of the amenities for a unit. Yes, you can contact one of the information coordinators and they can generate a report to send to you that will show you what the amenities are for your unit as they are recorded with us. Again, for the pre-99 tenants, there were extensive amenities that were listed, including things like balconies or appliances. But for tenancies since January 1st of 1999, we only collect information regarding the parking amenity, and if parking, storage, or pet are added, those also need to be registered with us. But for post-99 tenants, base amenities are whatever you had when you moved into the unit, and your personal testimony would be considered evidence to a hearing officer also. So that's how you might know what the amenities are for your unit. Somebody has a question about eviction, which we'll get to. So I have had no heat since mid-January. I've been patient with the management company, believing that it'll be repaired once the owner approves it. I don't think it's realistic for a tenant and the rent control agency to receive decrease petition every time something gets broken. Why the RC limit the rent decrease for the day the petition is filed? So for something like a broken heater or something that really could affect the habitability of a unit, admittedly, rent control is probably not the best remedy because our remedy takes some time. There's the 30-day notice period, there's an attempt at mediation, then there's a scheduling of a hearing, and then there's the time for the hearing officer to write the decision. So for something like a heater, it's better to go to either the health department or code enforcement, because those agencies actually have the authority to make the owner provide something like heat, which is required for habitability of a unit. Why the rent decrease is limited from the date that the petition was filed. It's because if a tenant has had a problem, and again, you can only go back 6 months before you can file a decrease petition with us. So you have to have given notice within the last 6 months. Because we are not able to gather the evidence from that earlier period, it would be problematic for us to reduce the rent going back to a time when we may not have had the ability to gather that evidence. And that's kind of the short reason. We did, or the board did change the regulations several years ago to change the effective date of a decrease petition from the first rent payment 30 days after the decision came out to effective when the petition was filed. It's still implemented after the decision is issued, but it's calculated from that earlier date. So that's somewhat of a compromise on that date. All right, I'll take a couple more and then I think we should move on. Somebody's confirming that they need to give a notice to the landlord. Yes. And I just said it is from the date that the petition is filed. By the way, you can get a notice form from our website, and it has typical conditions that apartments have, and you can just print that out, check those boxes, and deliver that to the landlord. Or you can use your own notice. Just keep in mind, text is not considered proper notice, but email is, if that's how you normally communicate with the landlord. But you do have to give written notice. Last one I'll do is hot water a habitability issue? Code refused to do anything about the fact that the landlord would not replace the non-functioning water heater. As I understand it, the working water heater is required. I don't know the specific situation in this case. It may be that the water heater met the minimum qualifications to raise the temperature to a certain amount. Again, that's really a question for code enforcement. For rent control, if there is any kind of qualitative reduction in the amenities that are provided, those could be reasons for a rent reduction. And so it would make sense to give a written notice to the landlord regarding this condition. And then if there's no resolution, maybe we can mediate a solution or have a decision in a rent decrease petition.
And
right,
just as an example, sure. Dan, so the ranges that are given, we do have loss or insufficient hot water or water supply as a typical condition that provides a range that exists in our regulations. And that range could be anywhere from $15 a month to $220 a month, depending on severity of the impact, the person's rent level, and other considerations that would be made by the hearing office. So that is something that is on there, not necessarily habitability, but definitely a loss of an amenity, loss of the value of your rent dollar.
Right. Good point. Okay, so let's go on to the eviction protections. And now we'll turn it over to Jenny.
Next slide. We'll be going over some eviction protections, and there has to be a just cause for eviction. So there are some that are tenant fault, and there's no fault evictions as well. So there is 7 fault reasons, and some are non-payment of rent, violation of an important condition of the rental agreement, causing substantial damage or substantial nuisance, refusing lawful access to the rental unit. No fault evictions include owner occupancy, withdrawal of property from the rental housing business. This is the Ellis Act, and I'll be going over a little bit more later on, and also a removal permit. For most no-fault eviction, there are specific requirements that must be met, including a requirement in the municipal code for the payment of relocation benefits to the displaced tenants. In some cases, a written opportunity to correct is required before the eviction process continues on. The end of a lease is not a just cause for eviction. So there are some restrictions to rent when applying for future tenancy if the eviction is for no fault reasons. And as I mentioned before, in some cases, a written warning must be given prior to serving a 3-day notice to cure or quit. So tenants accused of most lease violation, nuisance activity, or denying an owner lawful access to a unit must be given a written warning and a chance to fix the problem before eviction process begins. A tenant is entitled to use the owner's failure to serve such a notice as a defense if it continues on into the eviction process. Next slide. So as you guys may be aware, there were some local and county eviction moratoria. So I'll be starting with the Santa Monica one and then explaining the LA County one. So Santa Monica had an eviction moratorium in place. It ended in February 28, 2023. So residential tenants were protected from the following kinds of eviction: no fault eviction, including owner occupancy, refusing entry into a unit with limited health and safety expectations, having unauthorized occupants or their pets having limited health and safety expectation, nuisance, certain behaviors or conditions that would have normally been grounds for evictions with limited health and safety expectation, Ellis evictions, so removing units from the rental market. So another eviction moratorium was the temporary eviction moratorium for rent-controlled tenants. In order for this eviction moratorium to apply, all 5 must have been met. So this was specific to rent due from September 1st, 2022 to January 31st, 2023. The unit had to be rent controlled, and the rent had to be increased by more than 3% above the MAR in place prior to September 1st, 2022. And tenants cannot pay the covered rent due to a COVID-19 financial distress. The tenants were also required to provide notice and documentation to the landlord of the inability to pay due to a COVID-19 related reason. So for the temporary eviction moratorium for the rent-controlled tenants, tenants that qualify still owe rent and must be paid back by September 1st, 2023. So for owners may serve a requisite notice for the Ellis Act, but should not file. They cannot file the eviction based on removal of the unit from the market under the Ellis Act until 60 days after February 28th, 2023. So this day would be April 29th, 2023. And you would be able to find more information by typing santamonica.gov/COVID COVID virus-eviction-moratorium. Next slide. Next slide, please. So this is now the LA County eviction moratorium, which has also expired on March 31st, 2023. So effective July 1st, 2022, eviction protection for non-payment of rent including self-certification to establish affirmative defense for households with income at or below 80% area mean income due to COVID-19 financial hardship for rent occurring on or after July 1st, 2022. And to be protected, tenants must have provided notice to the landlords within 7 days of rent due, every month that the rent was due. And you could find more information about this by going to dcba.lacounty.gov no evictions for more information. Next slide. So this is eviction for owner occupancy. So there are a couple requirements for owners to be able to owner occupy or owner occupy evict. Owner must be a natural person with 50% or greater ownership interest, but owners can evict for a close relative as well. It is limited to only one unit in the property and cannot be used if the owner already has possession of a unit. There are specific restrictions on the selection of a unit, and permanent relocation must be paid to the tenant. If you received an eviction notice for owner occupancy, you could always call us and we will be able to explain the process and the specific details. So I'll explain a little bit more on the next slide too, but owners or family members must intend in good faith to move in within 60 days of the day that the unit is vacated and to occupy it as their primary residence for at least 2 years. And this is something that was passed when Measure RC was passed in November. And tenants who are terminally ill or have lived in their unit for 5 years and are over 62 years old, disabled, cannot be evicted for owner occupancy unless the evicting owner or the close relative for whom they are seeking the eviction is also at least 62, disabled, or terminally ill. So they would have to have like circumstances. Next slide. So as I mentioned, with the Measure RC, the owner would have to move in within 60 days. It used to be 30. And the owners would be required to live in the unit for at least 2 years after eviction in good faith. Next slide. So the Ellis Act is basically removing the residential, the property, withdrawing it from the rental housing business and would be evicting the tenants from the building. So tenancy terminate either in 120 days or 1 year. Withdrawal may be or may not be completed during the tenant's lease term. Individual condo units may not be withdrawn. The city ordinance provides additional protection against no-fault evictions for educators and students during the school year. So they would not be able to start the process within the school year. Relocation benefits must be also paid to tenants that are being evicted. Displaced tenants who income qualify may be given priority for the affordable housing option in the city. Property returns to rent control if they are re-rented. So displaced tenants may be able to return to the property if the owner re-rents within 10 years, and if the owner re-rents within 5 years, the rent will be restricted. And as I mentioned earlier, because of the eviction moratorium, if an owner is trying to Ellis Act the property, the eviction would not start until 60 days after February 28th, 2023, which means that they wouldn't be able to start it until April 29th, 2023. Next slide. So buyout agreements is another way that landlords could get the tenant to move out, and buyouts are voluntary and they are different from permanent relocation fee. So this is just an agreement between the landlord and tenant. However, there are things that the landlord must do, and one of them is landlords must give a tenant a written notice of their rights. And some of the rights that the tenants have is the right to not enter into a buyout agreement. the right to consult an attorney or the rent control board before signing it, and the right to cancel the agreement at any time up to 30 days after signing it. So if you look at the charts, the chart on the left, it is divided among the different cities, the city areas. So if you look at the map, the city is divided A, B, C, D, all the way to G. And depending on the area that you live in, we have averaged out the average buyout agreement amount. We've also calculated depending on the number of units in the apartment as well. So you could see that using these information, you could gauge how much a common buyout agreements are. Something that I do want to mention is tenants who accept a buyout offer will not be given priority to affordable housing as well. Last slide, which is questions.
Okay, so just before we move on, I just wanted to clarify these buyout agreements that you see here are just for 2022. So we have on our website more information with more rent history. In fact, you can download, I think it's an Excel document, maybe it's a PDF, of all of the buyouts, and you can get a better sense of what might be market value for a buyout offer. And the units indicated there are just the number of units that accepted buyout offers. So in Area 3, we had 3 buyout offers. They weren't in the same building necessarily, and they averaged 58,333. So this is just good information for tenants to know in case the landlord approaches them with a buyout offer and they are interested, because you certainly do not need to accept this. And as Jenny said, if you do, you will not qualify for any of the affordable housing units in the city if you would otherwise qualify. So, all right, so on to the questions on this section. We have a question: can I get a rent decrease for loss of habitability that is no fault of the landlord, such as major construction across the street? Jenny, you want to try that one?
So that's something that wouldn't be covered because it's not something that the landlord could do. They have no control over that.
Right. If there was an order that you had to relocate by code enforcement because of habitability for whatever reason, then the owner would be required to pay temporary relocation under the city's ordinance, even though it was caused perhaps by an adjacent owner. They would have to work out those details probably in a lawsuit or some kind of agreement between them about who's liable for what. But there wouldn't be the availability of a construction-related rent decrease. However, it is possible that if adjoining properties are owned by the same owner and it is construction work on the adjoining property that is affecting tenants on the next one, that tenants could file a petition for construction-related rent decrease. But it would have to be adjoining properties under common ownership. All right. So I joined late, and I do not know if this question is applicable yet, but the owner of the house I live in is selling the property. And the landlord, not the owner, gave us 60 days notice to move out and find new housing. Are we entitled to anything for the trouble since 2 months is hard to find decent housing? Jenny, you want to take that one too?
So that wouldn't be a just cause. Just because they're selling the property, that's not a just cause for eviction. So unless there is some other reasons to evict you, that alone of just selling the property would not be a just cause. So you would be able to still continue to stay in the house, and the new owners would just become your new landlord.
Right, and it's definitely not a reason under the rent control law to evict just because they're selling. Now, if a new owner wanted to take possession of the unit, then they could evict for owner occupancy, provided they met the conditions that Jenny described, which are owning at least a 50% interest in the property, no other owner already lives on the property, and there's certain limitations as to which unit they can choose. They typically have to choose the tenant who moved in most recently into the unit size that they want. But I would suggest if you've received an eviction notice to contact us. Owners are required also to file copies of eviction notices they serve on tenants with us and with the city attorney's office. And we can point you to some legal services that might be able to write to the owner and explain their limited ability to evict, and that may put an end to it, or you may need to get representation to defend what's called an unlawful detainer in court. But do contact us. We can see if the property is rent controlled and what rules apply. But you shouldn't have to just vacate after 2 months. So definitely give us a call and look up, and we'll look up the property and see how we can help you. Somebody says that it's kind of going back to how long is it reasonable to wait for repairs by the landlord. I'm approved for repairs, but was told I need to wait. What is a typical wait? I can't really tell you what a typical wait is, but I can tell you that after giving a written notice to the landlord and 30 days have passed, you can file a petition for rent decrease with us. And that may spur on the maintenance work that needs to be done. Yeah, just a couple of other questions. So this was about a rent decrease petition. This person also has been waiting for over 4 months for a decision from rent control. Sometimes these construction decrease petitions take some time because of the evidence that has to be gathered. But one of the differences, if you remember the part that Micah presented, was that any decrease that's awarded on a construction-related decrease would go back before you filed the petition, actually all the way to the point that the condition was proved to have started. So again, you would receive compensation for the duration of that time, from when those you started to have those impacts. So it's actually a longer period of time than with just the straightforward rent decrease petition. Don't see any other questions. If I have, let's see. For eviction for owner occupancy, if the building has many units, 90, and some are vacant, can the landlord still give a notice to move to one even though there are vacancies? What if the building is vested under a corporation or LLC? Can a tenant be evicted for owner occupancy? Jenny, why don't you take that one, please?
For owner occupancy, the owner has to be a natural person. So if it's under an LLC, then they would not be able to do owner occupy evict the person. But going to the first question, if this landlord is a natural person and there is many units and he specifically wants a 2-bedroom unit and there are many 2-unit apartments, then he would have to choose those first. But if there's a specific reason that he needs a 2-bedroom unit on the first floor because of his handicap or whatever other reasons, then he might be able to get that unit on the first floor, but that tenant could also then move to the other unit. But there are very specific. It would be a very specific case, and if it's just that if there's a lot of units and there's no, like if they wanted a 3-bedroom apartment and there's no units that are vacant that were 3 units, then he would be able to evict for that specific 3-bedroom unit. But it really depends on that scenario and who that tenant is and what their circumstances are as well.
That's right. There are a lot of protections for tenants, who are 62 or over, who've been living on a property for 5 years, or if they're disabled, have been living there for 5 years. But generally, an owner would first decide what size unit they want on the property, and then they could only evict. They would could only evict if there was not a vacant unit of that size. There's a variation of 15% in terms of square footage that is allowed, but generally they have to take a vacant unit if there's one available in the size that they want. And there's just the one exception really is if there is a medically documented need for, say, an accessible unit, then the owner could choose that unit. They can't choose a unit simply because one has more amenities than another. Both 2-bedroom units, one has a balcony and one doesn't. That does not give them the right to take the balcony. So there are limitations in terms of which unit which tenants can be evicted from which units. And again, the owner should always be filing copies of those eviction notices with us. And we get in touch with you, the tenant, right away. As soon as we see that, we advise you of your rights to relocation, advise you to get an attorney. And we also look at the property itself. And if there are some questionable things, like we see that there is a vacant unit or something like that, then our attorney can contact the owner and let them know the limitations that are in the rent control law. And with that, I think that was all of the questions. If I did miss your question or if it was very specific, then please give us a call tomorrow. We are closed every other Friday, but happy to talk with you during business hours. As I said, this presentation will be posted on our seminars and newsletters page. The next Rent Control Board meeting, if you want to get involved with what the Rent Control Board is doing, is a week from Thursday at 7 p.m. in Council Chambers. And you can always contact us at 310-458-8751 from 8 o'clock in the morning to and I'm going to get those hours wrong. 8:30. We changed it recently.
8:30 or 8 to 4:30.
8 to 4:30, and we're closed from 12:30 to 1:30 for lunch. And we get a lot of questions by email. And it's a pretty simple email to remember: rentcontrol@santamonica.gov. And we have a lot of information on our website, santamonica.gov/rentcontrol. So thank you for joining us today. Thank you for your many questions. We hope that we were able to clarify your understanding of the rent control law. And we do our best to share information. Somebody did post a question about why there's a disconnect between the landlords and the tenants and rent control. Well, we communicate very regularly with all of you. We send a summer newsletter, and it has very specific information about the rents and the rent increases and the notices, as we showed you. And owners, should pay attention to the information that we provide so as not to run into problems. We also communicate with tenants in the summer about the increase to know what to expect. We have newsletters in the fall And in the spring, last fall, we sent out information that was very specific regarding Measure RC and the effects of the adjusted general adjustment. So, be sure to open up the mail from rent control, and all of you have done well to join us today and get more information. And we look forward to seeing you. Thank you very much.